So welcome back, everybody. Before we go to Council's response to the evidence we've heard, we just want to discuss one more brief of evidence for a party not attending, and that's from Z Energy. Ms. Trinder, you're familiar with that brief? Yeah. I'm just wondering, have you got any responses to what was set out in that evidence, because it sort of addresses the 42A report quite closely, particularly the concern about discretionary activity states.
Yes, I guess looking at service stations there was initially going to be a discretionary activity. We've maintained that discretionary activity status because we do believe there are some adverse effects that could come from a service station in the mixed-use zone. We've touched on the conflicts of multiple different uses in a mixed-use zone. Yes, I would have to do some further work to determine if I do support the recommendation for restricted discretionary activity for service stations.
I suppose I'll just play devil's advocate for a moment. And the effects of service stations, particularly in a commercial zone, albeit one that allows they're reasonably well known. You could count on your fingers the sort of matters you usually address when it comes to service stations: noise, hours of operation. There'll be a bit of sort of hazardous facilities rigor and ensure that they're following best practice, particularly if there are people living nearby. But again, we're in a commercial zone. Obviously, the transportation and traffic issues, and then a general sort of amenity frontage and association relationship to other properties. But they're all sort of reasonably well-known matters that could support a restricted discretionary activity status. Or do you think there's something about it in this context that needs that broader discretion to consider other matters?
I would largely agree that a lot of the matters can be determined for a restricted discretionary status.
Yeah, okay. Well, I think we'll just leave that there.
Yeah, if I just add to that, I think that there is a good case for restricted discretionary activity. As Robert says, the effects are pretty well known. Presumably, just as long as there's a size constraint on it, some mega service station sort of style. But some of those assessment criteria that's in the evidence here, where they talk about landscaping is provided, especially within surface car parking areas to enhance amenity values. I mean, that's. I just don't know how a processing officer deals with those sorts of criteria, quite frankly. But I think as an ADA, they could be made more specific.
Yeah, and thanks, Alan, because you're segueing into the other comment I just wanted to make was about landscape. It seems, this is sort of my experience with service stations, and that's, I'll concede I have been an applicant's planner for a service station in the past. I've certainly assessed a number of them on behalf of council and as an officiator as a commissioner. It seems that the question of fencing and landscaping is all about the side and rear boundaries, mostly about the side and rear boundaries, particularly if you have residential activity and result interfaces there. You would the fence provides visual relief, but also noise relief to commercial operators. It seems that as a restricted discrete, we want to ensure that you achieve a certain level of noise proofing construction. Question of the landscaping, it really seems a bit odd because the landscaping often goes inside the service station. Whereas often when you're listening to submitters, they want the landscaping on their side to mitigate, to give them some visual relief. But usually the landscaping goes inside to give some sort of visual relief to that activity, and probably the degree of fencing that's there to take the sort of starkness of the fencing away. But a front boundary, putting landscape on a front boundary for a service station doesn't really, I'm not really sure what the argument for that would be. you're obviously, you've got to be cognizant of the sweep paths that the tanker truck has to take, and they have to be quite gentle, and you're obviously wanting access to be open and seen. Cars coming in, cars coming out, trucks coming in, trucks coming out. And I'm not sure whether there's any argument really for landscaping in the front. I'm happy to be convinced otherwise.
I think, Mr. Chair, that the difficulty, as planners notified, from our view, in looking at the submission wasn't entirely clear and talked about health and safety reasons. But a 2 metre high landscaping requirement, it does not work with that. But I think that was probably the key area that we looked to compromise on, which was to bring that height down. Was it 1 metre?
So they have sought an exemption from the height for the landscaping.
Yes. So I think that is an appropriate compromise. I think it was 1 metre.
So it's continuous green of 1.8 metres within the first 5 years. So the height of 1, then up to 1.8.
And that applies to which boundaries?
To the road boundary.
Yeah, because as I say, I think the argument applies for side and rear boundaries for obvious reasons, in combination with fencing, particularly if you want some noise proofing as well. But I'm actually struggling to see any examples of front yard screening in a service station.
I can certainly point to a very famous one on the two, but having you asked Mr. Chair. In my experience, there are various parts of I think it is site specific in terms of whether it fits in a particular environment. Again, we're talking about quite a zone framework that's relatively narrow and more particular mixed use zone, commercially focused. So maybe with slightly higher levels of amenity. Just turn off that their evidence, but I think we'll consider that further as part of our written reply.
Just have a think about, because often I've had evidence presented back to me that says the frontage needs to be really quite open. That needs to be open for traffic safety, truck manoeuvring purposes, and you don't want drivers, having their used cars coming in and out obscured by screening. But they generally tend to accept that the side and rear boundaries need to be fenced and planted. That's my experience. And having said that, if there is a particular argument that justifies it, these particular zones in this district, I'm sort of open for that as well.
Yeah, and landscaping is not necessarily planting either. Whether you want to be more definitive on that, landscape planting as opposed to landscape planting.
I think they're talking about planted and growing in the first 5 years. Yeah,
well, I believe it is. Yeah,
and the other question is this: they raise this interesting issue about EV chargers. Obviously, service stations have seen the writing on the wall, and that that they are providing energy not just in the form of hydrocarbons, and they're obviously shoehorning EV chargers into existing frameworks and existing sites. So have they got a point there about EV chargers in the front yard? Whether that would be a building and triggering discretionary activity consent if they do, restricted discretionary?
Yes, I do think that it will cover under the definition of building, so it would be captured by this rule. This is the EV argument here is the first time we've seen this, so we can consider it for the 42A report.
Yes.
So we can do some further work on that.
Yeah, I mean, it's first I've heard this argument too, but it seemed to make sense, doesn't it? I mean, maybe you just say not include, but excludes EV charges. Then again, and of course, it may be that they put a little shelter above them. Well, I haven't really seen them with shelters, but it's possible.
The energy group
I'll do it.
Yeah, sorry.
I've seen a motel with a recharging cord running out of it, bright yellow and across the hall.
Well, it's a particularly long quarter.
It was, yes.
Mr. Chair, on the point that I think that Mr. Trinder was making, that the evidence of the around landscaping wasn't that they exempt from it, but the height,
The height, yeah.
the height,
Yeah.
right? And I think we're reasonably comfortable with that. Probably the particular sight line, pedestrian and traffic interface reasons. I think that makes sense. I think the submission was a little bit vague in terms of what particular health and safety issues they're concerns were, but I think this is helpful for that.
Yeah, so obviously, I mean, yeah, looking forward to your response to that particular, that particular piece of evidence in your reply. I suppose the general comment is, we'd like your reply to address all of those pieces of evidence that have been submitted but not attending, and whether you accept any of those arguments that have been put forward. Anything else? Okay.
No.
I know that the Sale of Liquor Act and its, what do you call those things? Case law probably has it quite covered off, but I did wonder if the reverse sensitivity needed to be in the, that you can't have a petrol station near so close to a liquor store needed to be in there, but probably not because of the case law that surrounds the Sale of Liquor Act. Yeah, I don't have a response on that at this moment. I will have to do a little bit further work.
Vera, like Commissioner Vera, by Central Guardian Station, by
Responses. I'm so quite happy to get questions from the weekend because you'll probably be thinking and want to discuss a lot of the things that we would ask you to discuss. So why don't you go to if there's any other questions that we jotted down, we can put them to you at the moment.
Thank you, Mr. Chair. I know it's probably not quite as comprehensive this time around, I'll be honest, so I will be relying on Mr. Trinder a little bit to support me on this one. We know we have some discussion on, I guess, the nature of activities and play. Of residential and visitor activities and what settings might be appropriate and to what extent that exemptions or differences or changes or amendments might be appropriate as well. We think that warrants further consideration. On the face of it, we might consider differentiating between visitor accommodation and permanent living accommodation, noting that there is a range of activities, but we'll look into that more closely. We'll make a recommendation on that. There is a range of evidence that was from so there was some House Movers Association. Is there any? I think we can again restate our position on that to you.
Yeah, well, look, I think we took Mr. Barnard Thompson.
Yes.
I think we took him through. I think we sort of helped him. We explained your position to him, and he seemed to accept that that his position. Because I think what we were having is that he was saying you need to make these things clear in the plan, and you also that we had it's already there. You just need to follow the route. We took him through that. He seems to accept that. So maybe you could just have a quick discussion about that.
Yeah, look, I think it would be helpful to we just restate it.
Because it would certainly help our writing if we would say we support Council's position because we are satisfied that his relief has been met, albeit by other means.
Yeah, he got a bit confused by trying to sort of move into this idea of uniformity across a number of district plans.
Yes.
To my mind, we had it covered.
Yes. I think it is.
We hadn't really sort of picked up. That was a request.
And we talked about that template, and that raised the question of how officers, not you guys, but the monitoring enforcement team would have to undertake or receive some that document. Were you guys going to?
Oh, yeah, the cost, that question you raised, which I thought was a very good question, is are you actually introducing extra costs?
Yes.
Yeah, my understanding is that it was a conscious decision to do as an aliens we could have a house model that was for a long time. The most economically viable way to provide for lower costs housing. I'm not sure whether that's still the case, whether actually the market conditions have deteriorated further than that's not even possible. But my feel, or to quote the Commissioner Rice, the vibe I get from the provisions is that there is a conscious decision to be as light touch as possible.
Yeah, certainly.
Right, so main freight. So there was two things in particular here, I guess, was the height limits, which is an interesting discussion.
16.
16.
Yeah, and that seemed to be compromise. That was for the heavy industrial, not for, I think what I recall at one point, whether this agreement with 12 metres was probably acceptable for light industrial, although we go back and double check that. The discussion sort of went around a little bit further, so we might rely a little bit on going back and just filling some of the gaps in terms of that knowledge. There was also a comment on front yard landscaping provisions. There was a suggestion that the landscaping and yard requirements rules do not work well together. We're quite clear on that. Again, some of our definitions around industrial activity.
Yeah, I thought that was quite the most interesting issue for you to contemplate. And it seemed to me that there's a number of ways you can slice and dice this, and I don't think any way is particularly right or wrong. It's just about whichever method you choose, just make sure that it'll work. But I think what he was sort of saying is that you can define everything, just define industry, differentiate between the types of effects that you would experience in a light industrial zone or a heavy industrial zone. But having said that, you haven't got an integrated unitary plan, so you can't just refer to regional provisions. You're having to defer to another planning instrument. You're going to control things by discharge. So I'm not entirely convinced of that approach.
So with this context anyway, I think, Mr. Chair, I think it'd be fair to say that we need to look at the way our plan works and what actually happens in our district as well. Acknowledge the evidence is good and robust for in particular Auckland, it makes sense. I think our situations probably tend to be a little bit different. So look, our responsible acknowledge those pieces of evidence, but our responsible confident with the situation that we have. We try and make sure that our framework overall remains coherent if we can. We have to make some changes, for example, around town centres, and we'd like to make some provisions, but I think when we try and answer you on these things, we don't want to look at the issues in isolation. We want to look at it as part of another. So, some good points, something I agree with, but I think we could probably use all words, make some jokes as well. Yeah.
Josh, I just want to sort of throw a slight So what page of your report you come up with the definition, your definition of financial activity? Just trying to remember this.
It's in the definition section.
Yeah. It's a new, is it an existing definition?
There's a new definition.
That's it up. Which, whereabouts should I just want to have a look at the wording of it's got a couple of which that's what I mean.
Okay. Issue 2 is
I was going to say, have you got a recommended amendments to definition? Oh, yeah, from there. Appendix 1.1. That should have it. Code supply. Well, oh, yeah, here we go. Ah, yeah, my question was, yeah, does it include processing? Because I think in the 42 report, you didn't say processing, but the definition does. Yeah. That was it. It's not real, it doesn't include processing, but it does say so in the actual definition, so that's why I'm just clarifying that. Okay, no spoke. Any question?
No, just definition. Yeah.
I just had a note on the height that is it 16 meters for both was what I wrote down, and I've got is that 24 dash meters square or kilometre, because that permitted, but I think this is for permitted in the heavy industrial zone and discretionary in the light industrial zone or height. That's what I wrote down. That's what will come back when you listen to the recording.
Cool, thank you.
Clarify that you only put 120 meters if you're expecting a purpose-built logistics facility. That was more than warehousing, but it was basically a distribution centre for a number of retailers potentially. And I thought, well, when
How could make it that?
Yeah, well, what circumstances? I'm thinking, yeah, well, possibly you could see one in White Park, right? Where you've got all that large format retail just around the corner, and that there could be an argument for a logistics center at that sort of height. That is literally warehousing the stock for those particular activities and a whole range of other people that they can. But at the same time, it's a bit like the sort of Kiwi Rail example. Do we really need to provide for, is this a sledgehammer to kill a flea? Are we really needing to provide for an activity that Mr. Allison himself said his client isn't really contemplating? So,
I think it's something we wants to, in another phase of implementation, say for example, research. I would suggest that those types of activities are most likely to occur probably given the proximity to a whangahei, but also port. They are receiving things in a port in an estimation. But I would say if we're looking to go significantly higher than the 16 or 15, then it would probably consider that.
and depends on enabling, financial heighting, if you go above 16, yeah, if you go above 16 metres, 12 metres, or 16 metres, what would the activity status be? That's pretty agreed.
The 16 is kind of more.
And I have to say, that sort of thinking, are we using a sledgehammer to cover? That applies to the nesting table question as well.
Yeah, well, I'll do the comment on that. But first section, Mr. Trinder, do we have an example? What's our tallest building in the district, do you think?
We don't factory.
I don't think we have. Do we have a dairy factory?
Yeah, well, there's a dairy factory that's out just outside of
Bangladesh.
and I was like, are we in Far North yet? Because there's no sign that.
Oh, Zasco. Zasco's not that. Chimney stack
Yeah.
building.
I'm wondering if it would actually be the kiln of the timber
Yeah.
timber mill at Cartire.
So yeah,
Town.
probably a narrow structure, but so to even providing for a bulk, like height, is probably certain points maybe less bulky and imposing height, for example. And that's profile, so. In terms of the nesting tables, we have used or suggested them in one, not necessarily as a provision in the plan, but we have used them or highlighted that as part of the rural provisions. And this Pearson talked about pulling them out the certain types of primary production activities for particular reasons of compliance in particular, or to control specific things under highly level policy documents. The primary production in its entirety wasn't the idea, it was more specific in things like farming. So when, for example, primary production includes mineral extraction activities, for example, pulling those out. I'll just suggest, it is potentially a lot of work, or a lot of work. I would say that we have to be very cautious that we aren't imposing new meaning to the intent of some of the rules, provisions, particular policies that are provided. Yes. But we can have a look at it. We just need to be a little cautious.
Do you agree with me that you do it the one you do it for?
I would agree. It's a plan structure.
Yeah, it's a structure. And that's a next question. This is why I said, I think there's probably a number of ways that you can impress Mr. Baden's evidence if you accept the issue. There's a number, I mean, and looking at that definition, that would be potentially quite a simple fix if you didn't want to mess about the structure. So I'll leave it to you as to whether this could destroy the things back. Finally, we have to do nesting tables.
Yeah.
Or whether it's like, no, this is a sledgehammer to kill a flea. We don't have to amend the whole structure of the plan interpretation section to address the issue of foodstuffs. But if it is a cumulative issue that's been building up over other things, like rural, then maybe this is the one that sort of triggers that response. We accept that there are a number of ways to, there's one, two other ways to address this sort of thing.
Yeah, I think acknowledge that just tweaking some of those.
Just like nesting tables a lot.
Would sort things out, rather than doing wholesale changes.
So what are the sort of questions?
There were a few others. There was there was comments on steep height provisions, and I think there was also one of the policies regarding efficient use of the zone instruments.
Oh, I thought Mr. Allison sort of said at the boundary, if you're enabled 20 metres, you could have it applying at a certain point within the boundary, sort of like a step, like a boundary control type thing. Is that what I think that's what he said.
That's one of the issues, yeah.
Happy to hear your thoughts on that.
Right.
Again, it seems to us if there was a clear demand for activities existing, proposed, or clear intent to establish that needed a 20-metre height limit, then maybe you respond that way. But if you're dealing in the theoretical realm, I accept that you may not need to solve that issue.
There's a little bit of overlap with some of the submissions of the community rubrics as well, on step heights as well. So it probably makes sense to address those. Yeah, and the other one is policy about what was being managed. I think we looked at as well. People on. And to recall, there was another matter here that around the focus of the management plan. So that's also. Yeah. I think that does bring us to corrections. This is a fair amount to go through here this year, I think. So we'll go through that comprehensively.
Yeah,
It all boils down to the commercial side. I mean, I think they're quite satisfied with the light industrial zone.
yeah, as I understand, there was two issues. So the light industrial zone, community corrections facilities, is a permitted activity with a cap on it or 12%.
There's a cap.
Sorry, so is that specifically on campus activity status in the issue zone?
Just a mix.
We do cap other activities and zones where that could potentially be sensitive to the yeah.
I'm sort of wondering, whether you have a cap in the light industrial at all, and potentially have a do something with a cap.
Yeah, that's something to give consideration. One of the other they were talking about is that we have provided for trades training in light industrial zone, which was one of the activities anticipated as a community correction. So that could be where we would see the bulk of people in the light industrial zone for that activity. So,
I mean, is the issue, what's the fundamental issue of not making it a permitted activity in the next use zone? Is it the fact that it involves people who have been convicted of crime?
my understanding was, I guess it comes down to being really clear on what the activity was actually going to provide for. So I think we've got a little bit more clarity from the evidence
Quite a clear description.
on what it actually is.
Yeah, I think that's right. I think we sort of build in some gaps that I understand. And I think it also reflects the standard approach of, if it was an office or just a general education facility and a mixed use zone that would be controlled as well. So in terms of its approach would be generally capped. So it's not to do with the persons, it's the activity, potential activities that.
It would be helpful if you made that clear in your response. Because I think that was the feeling that they conveyed to us. That you don't need these people who have been punished and released, and that this is part of their release program.
Yeah, I can certainly recall that that's not the intent and was never the intention, to my knowledge.
Yes. And I'm not suggesting it was, just an opportunity for you to make that quite clear, because it sort of came through in their presentation.
What the communities are seeing too is that these things are happening already in our communities, but there's no sign on doors saying it's Department of Corrections. For example, in Kawakoa, that big massive building, New Flow on the other street, they have Matariki Court in there. So, and they have their check-ins at upstairs and mental health services for those without event, with no drama. And I think we're making it prohibitive by the district plan sort of policing where that goes. If it's the Department of Corrections doing that,
Positive and the points that we had.
So I think what you're saying is that it's operating quite successfully without any fanfare or massive signage in Kaukau at the moment.
And in Paihia, and the community doesn't even notice.
It was also helpful for them to emphasise that it was non-custodial.
And
that they don't need to be supervised because they are just sort of.
they're just living their lives. They have to check in and suddenly count with.
And also too, I think what's quite helpful from the evidence also too was that there is a clear overlap with health provision. It's not just a corrections activity, but there is a clear overlap providing health services, including mental health.
80%,
70% of people in the prison system have a mental health issue condition. So it's not designed to be punitive. also provides needed health support to assist people reintegrating back into the community. I thought that was quite an important statement from them, which is why I wrote it down very carefully.
It probably moves us on to what I'll collectively call the Kerikeri environmental groups. We have asked our urban designers to review the evidence, the relevant evidence, to see where we agree and disagree. Trinda explained to me the height.
Yeah, I did have a chat with Ms. Rennie before the hearing to understand their urban design evidence and what that actually meant for Kerikeri. I probably shouldn't briefly explain that in design terms, but I do understand the concept, and I can get Ms. Rennie to provide further statement.
Will we be seeing Ms. Rennie as a witness at some point?
She is available online. If we have
Oh, no, I mean, I'm just sort of, yes, maybe she'd be available
she,
at the 15.
Yes.
we will have them in person.
Yes.
Oh, in person, yeah, that's fine, because I understand why she's not here at this hearing, because we haven't, what we've got is literally a section 32 report, but we haven't got provisions, and I sort of concerned that you are intending to bring her as a witness, so that we can do it. You're elected to cost it, doing it in person.
It is our intention to bring her up in person, 15C and D. She has the peer-reviewed evidence on both those.
Well, that's excellent. Okay, well, that's great. We definitely endorse that.
And just as I noted there, she is available online. If you have any questions for her.
Probably the main is that sort of stepped approach that they thought was a good response, albeit you'll be working within an existing environment that will stay reasonably controlled.
Yeah, she has read the evidence, and I did indicate to her that we have submissions on that, so we can get her on the call.
She can ask this one. Maybe this one, this one. Yeah, because I think what we'd like to see is a response to the themes and evidence in some of the specific provisions that they thought were at least that they brought an expert. So.
Absolutely, yeah, absolutely.
I mean, they're a very passionate local group that a lot of time commenting on these things. So I think they deserve a good response.
I like the chat sat on getting closed down every time we wanted to say it was closed down. But when you look at the town centre zone, it's going to evolve as such. Would that be the place that some of their concerns are taken into account? I mean, they've got a number of design.
It's a chicken and egg situation, I think, Mr. Chair, in that we don't actually have anything that's been appropriately consulted to legal detail. It's probably helpful. So in terms of their request for mandatory adherence to these documents that haven't been through a plan change process, or even if they've done themselves with third parties, I think is that being said, we included the idea of design guidance through this. There will be, we're in a situation ultimately we will have a zone, and that it may become public without yet further design support will be assessed, and the provisions will be assessed for urban design character and management appropriateness. Further design later, so the regulation will be go forward, and not so much but this is what we consider as a starting point appropriate.
So in that sense, I mean, that's really good. That's sort of what we're thinking is the town centre zone is the step of the zone, and that it's future proof to allow master plan, a similar type of approach to be added to it, design guidelines. Is that what we're talking about?
Yeah,
This
so
process doesn't establish that master plan, but it establishes a framework that will allow.
I think what would probably be, it won't include it. I don't. So I think we'll have to do that. We'll bring in a particular plan change to be able to do that.
Yes, yeah, we thought that's right. That it could happen either in the variation if you're allowed, or a plan change if you're allowed, another time. But framework is there to embrace that.
I think it would be, on the face of it, it would be challenging to start to recommend consideration or something that don't know what process is going to go through, we don't know what the content is, we don't know what's going to look like, who it's spoken to. I'm struggling to see a way we can provide direction on it.
So one of the questions I raised today was around the implementation plan for the wildlife spatial plan, and my understanding from those, that interaction yesterday was that they would do the design guidelines through that process, which is not statutory. So the design guidelines would be referenced in the Waipapa EP spatial plan, but not in the district.
But potentially come out of the work as part of Prosecuria, but
They're not going to wait. They're going to pay somebody to do their own master plan with the design guidelines that they'll submit to council to include.
Process, so I can't guarantee I can't sort that process. Or
But what I'm trying to understand is how the district EP reference will acknowledge that work.
probably not the place that's recommended most. They can do that. There's no guarantee that that will
In
recommend.
terms of decisions.
Uphold the design guideline.
There's no guarantee that we will actually recommend even adopting as a statutory guideline. That might just, and one that might be one encouragement approach as opposed to a statutory approach. And I think one of the fundamental points that they make, they want a hard and fast explicit document to which they hold developers to account. And in my
Very
sense,
prescriptive.
my sense is the industry is not, or that's unlikely to pass muster on board.
Yeah.
They design ways to that very quickly.
So it's good to have that in there because they if there's any gaps, they'll come ask. It needs to be pretty clear.
Yeah, I mean, I think we sort of said, highlighted to the news today, but actually it's a, because we're getting them, it's also a proposal. Second part of the questions might say is, there's also no guarantee that there will be very prescriptive document that will be passed in terms of district plan. And it's interesting,
It's too late, please, to add that.
It is exactly. I use the Maritime example. I worked in places like Hastings that have quite considerable guidelines. Honui as well, which has extensive consideration of that sort of. I've worked a little bit and what up the communities asking for things there. I mean, I would suggest that sort of discussing with the urban designer what they're looking to protect. It is not, say for example, the parallel that they used was Arrowtown. So very different, very specific character, very identifiable character, and very strict guidelines that motivation. I was working on other districts and I took back because I was holding back development. So the question is what in the Kerikeri town centre, how can you define, how specifically can you define, or are we talking about high level concepts that refer to things like active cottages and and windows and things like that, which we, for example, if we're talking about height, we would need to check that practicality against the engineering requirements. Like, you can only have so much glass if you're looking to go so high up through engineering requirements as well. So, yeah, at this stage, any comment would probably be ridiculous about recognising good design. For example, we didn't really receive any written that would help us or direction help us from this mission specifically on it. In any way, nebulous approach is not what they are sort of seeking. They're seeking quite specific design.
Yeah.
But again, we'll put that through this ready and we'll provide a response.
Yeah, thank you. And if you could specifically turn your mind to this, the outcome of prescriptive design led and the notification presumption, I'd like to hear council's view on that particular. And Ms. Reid has anything to say as well about that.
Yeah, I think I think this is, you put these things together, as you know, sir. You would, if there was something that was significantly breaching a height limit, you would consider notification or out of step with character. It's so specific, and one thing that design guidelines could be useful for would be to understand the anticipated community or public facing, public realm outcomes. Again, which we don't have at the moment. I think it's fair to say that mandatory notification for height is probably unreasonable. Even if that would include if there was a I think steps of test and section overlay are appropriate, slightly relevant to survey assessment at this point in time.
Yeah, I agree. It's obviously the test is significant. Effects that are more than minor beyond adjacent property is probably a trick still, and that's always should, as long as that lasts. That's why sort of height tends to be the one that gets things notified, because the effects of height can be experienced beyond those adjacent properties for limited notification. But having said that, the only instant notification all I can think of is volcanic height infringements in Auckland, where you're instantly notified whether it's a centimetre. I think the other one too, again, I know Auckland so well, was residential activities in a certain business. But other than that, it's used really, that's the point where I'm agreeing with you. It's to be used quite sparingly.
Yeah, I don't think you want to get too much into the whole notification issue, quite frankly.
And I think
The whole business of minor and less than minor.
I got the feeling that they're wanting to send a message to the development community as opposed to particularly trying to address a particular type of effect.
It's kind of all the development that they previously had issues with, that section 95A hasn't worked.
My recollection was, did they say that they should comply with height? That development.
Density.
Yeah.
And the impacts on traffic.
And this is where it's, I mean, I wasn't going to take them to task on this, but you've got the MPSUD, which basically says you're not really supposed to, we're looking at greater height and greater intensity, and we're not looking for you to make that an amenity. Policy 4, I think.
Yeah, I think to be fair, as I say, we've heard through much clearer in this process that the amenity and character is important, and what we look to do is something that is, as much as we can do reasonably and fairly, accommodate both. So we're certainly not saying we're looking to walk away from values of the community whole town centre, absolutely not. We just want to find a way, a principled way to achieve what's required of us in a modern planning environment with the needs and desires and wants and values of the community. So we've got to balance those two things and what we can reasonably achieve under the Act.
The developer at that table yesterday said that he recognised tier 3 had been established, but he was concerned that be treated by 1 or 2 or some. So I do wonder how you're going to, what's his words, temper, have those safeguards for tempering.
Maybe perhaps unpack that a little bit. The tier 1 and 2 authorities are specified. They're named. They're told who they are. There's no threshold. They're regional centres, generally speaking. Well, either major centres or regional centres.
Yeah.
What I would say is, yes, there are some requirements that apply for us as an urban environment that do apply across all of them. But we do have different expectations as a tier 3, and I don't see necessarily changing measurements. So,
I think NPS says if you're a tier 1 city, you've got to do all these things. If you're a tier 2 city, you've got to do these things. And tier 3 is sort of encouraged to do. But of course, any developer turn up. So in order to be a operation in the urban environment, you should be doing all these tier 1 things. And I think we just have to deal with that on a case-by-case basis. Yeah, okay, that's quite a good thing, I think.
It's really helpful solution. Yes.
It's a bit terrifying. Some communities are so that's helpful. So I suppose we're moving on to the evidence we've heard today.
There's some developments and contribution.
Oh, yes. Kelly and I had quite an intense discussion about that already. So I thought we'd already discussed it, of course, now.
Yeah, you might have, I think some of the, could be some useful practices in this.
Yes, it gives us set out what council's policy is. Contributions and what's coming. Just to confirm, we're taking on contributions on a case-by-case basis. And the development contributions policy.
We're entering into developer agreements.
But that triggered by development. And the development contributions policy is being assessed at the moment.
Before council, the draft.
Yes, that's right. To go out for consultation.
So that decision will be made by the time you get there.
Fingers crossed. So Roger Atkins, General Manager, could come up and tell us a bit more about that paper.
Good afternoon, Mr. Atkins. We'll throw you straight into the hot seat. We're talking about getting
yeah, so we've got a draft table for the council. I think it's July. That's draft consultation. So following the SCP process and the Government Act, we'll take it up for the standard time frame, which is a month. The plan is at the moment is bring it back to council in September for adoption. But that's subject also to the amount of submissions we get on the policy. So but we're anticipating a fair bit of interest in it. So the policy as it is right now, is the work that we put into it is to figure out which of the projects in our long-term plan are growth related, and then how much of each of those projects, optimal of it, is growth related. As you know, a project can go in there and it can be actually just level of service part of it, and there'll be a component of just growth. So we've had to make that assessment across the projects, across transport and across waters. We're not putting in parks or reserves into the development contributions policy. The plan is to hold off until we have a financial contributions chapter in the district plan as part of a plan change. So that's it in summary about where we're at. Enough.
Okay, no, thank you. Thank you very much. That's really helpful.
And the question that the submitters yesterday wanted to confirm was that although, for example, the Midday has been subdivided on consent application, should that DC's policy be in place votes,
Yeah.
consents should be liable for
Yep.
DCs.
Yeah, well, the way I understand it is once the development contribution is adopted, then it's applicable. So any connection, so water connection or a building consent or resource consent will trigger a development contribution a charge.
Great, thank you.
I think I've got that wrong.
Feel free to stay there.
There was also from the comments on heights on the ridges, and that they should be high, lower, as by the river. We'll provide some evidence on that. I sense that there's probably some quite significant issues about that approach. So we'll probably provide it. And also some of the stormwater discussion as well. Just to reiterate what we've seen. Challenges around achieving that at this stage. So that brings us to today.
Stormwater, this stormwater is that impermeable versus permeable surfaces and we're not gonna
I
go
think
any further with that.
I think their presentation sort of said impermeable and permeable, but when you actually look at their evidence, they were discussing actually the wider range. They were just focusing on those two things, I think, in the removal context, but the evidence did acknowledge potential retention reuse.
But officers rejected their submissions in the section 42A report.
We'll provide a response.
Cool.
Probably in a similar vein. I mean, the other side of it is that I had a discussion with one of council's engineers, development engineers yesterday, and these soft solutions tend to be very expensive to maintain, and that cost can fall on council. And so the provisions in terms of how we manage that is actually also beyond the realm of the district plan. It's part of engineering requirements and consideration. So that the desilting of a pond and monitoring and responsibility for discharge consents could fall to council. So there's an additional cost to potentially council as well. So it's not necessarily simply just for individual sites provisions, but as I say, we simply really don't have enough information to confirm. And governments to accept those assets, for example, to move forward this stage. Not saying that there's a potential issue, but also the scale and scope of the issue at the same time.
It's through this consent process that take Waitia, for example, in Harugu, there's a number of stormwater assets there that once that development is at a particular stage, it's a consent that then becomes council's asset. And I don't know what the interface is with between the district plan and all that cost decision. You know what I mean?
Yeah, absolutely.
It's
Absolutely.
huge implication.
Yeah, absolutely. And that's part of it. And yeah, at which point this is the benefit without sort of stepping too far back.
Yeah.
This is why work-life security is and the subsequent implementation is really important. So we can consider those things as part of our growth planning. So we understand who's does what and what's required.
Yeah.
We are at this stage in the process starting in its infancy.
The district wide.
Right.
Yeah.
So, I think it's important to acknowledge that you've got to walk before you can run, and robust, well-considered decisions are very important for a community that's struggling to fund its infrastructure. So we need to be very careful, very clear, very clever about how we identify and provide and manage growth.
We can't manage that through PDP.
I think through an ad hoc basis, through resource consents is problematic. And I think my sense is that's perhaps what has happened historically, is we've used the resource consent process in some instances to manage our infrastructure, where actually it should be the other way around. Our infrastructure, which really should be driving more development.
You sort of talk about soft infrastructure and the costs. Rain gardens are all the rage, still are, particularly when they were advocating public roads and like, and going along with subdivisions. So we will put rain gardens in all the public roads until the roading operator realised how much it would cost to maintain those assets, and they now show up at hearings and say, "We don't want rain gardens because we don't want to be responsible. We haven't got funds."
Yeah, there's also the on street car parking too.
Yeah, but I'm just sort of wondering, is it in the mix of what you're considering, and it might be relevant to your residential medium density, is the option to have a rain. I mean, I know Auckland Council did a plan change back in the days when you were allowed to do them. Auckland Council did a plan change specifically providing for rain and excluding them from resource consent requirements and certain dimensions and volumes.
Yeah, I think we touched on that in the previous hearing. What is it, the rural? I'm not entirely sure, actually.
So, I mean, I think one of the things in your toolbox is potentially to allow, particularly when you're getting into high densities, to allow rain tanks of a certain size and dimension to be established without it sort of chewing up the building coverage, because you are effectively dealing with impervious surfaces as opposed to creating them. And without the presumption that they have to be buried.
Yes,
So you can have rules that say, well, it's permitted to do this, provided it's placed there, and a certain colouring, you can have some specifications, and that's possibly one of the mitigation tools.
Yeah, so obviously the provisions for a particular medium density is yet to come.
Yeah.
So we've got an opportunity to.
It's not so much a misreading question, it's really sort of like a sort of engineering. I mean, there's a little bit of a urban design element because you don't want big ugly rain tanks sitting in the front yard destroying the streetscape. That's why you have criteria where they go and how big they are, what colour they are.
Yeah.
But it's potentially quite a nice option to have, particularly wanting to detain some salt water, whilst also wanting to have a little bit more intensity at that peak time. Something to consider.
That's about it. All of them. So we move on to Mr. Bedham's slides. Acknowledge that we have provided a spatial extent to uncertainty. However, that kind of is what it is.
Well, it's uncertainty for a couple of things, several things.
Well, it's uncertainty to weigh, Mr. Chair.
Well, they'll know the provision.
Yes, absolutely.
When the 42-hour report gets released in 3-4 weeks.
I think the perennial question of supermarkets through all the zones that we talked about definitions and sizes.
We had quite I reported quite a long discussion about supermarket sizes. It was rural areas.
Yes.
And the question was whether a supermarket deserved a little bit more. Given that it was a really important retail function as opposed to other types of retail. And we just sort of thought they had some merit.
Yeah, I think the decision we match, I guess, the settlement zones is identified. Like there is one site, whatever is, and I think we recommended a specific exemption for whatever on that basis because of the function or that sort of settlement provides, or the size of that. And we have a lot of other settlement zones that are essentially very small, very coastal, in many instances. They also have settlement zone zoning, probably wouldn't. But we also, we generally apply particular settlement zone for commercial activities generally as well. My recollection is that there's one activity in that. So yeah, we have
Just to that point though, I guess that was my intention behind the restricted discretionary status for supermarkets as compared to large format retail, which was one of the things that picked up on. So there was that community essential element.
Yeah.
That was my pull to make the supermarket slightly more labelling than large format retail.
Yeah, yeah. So that seemed like a reasonable submission to our CEOs. There's a whole question of hierarchy. I mean, we go right back here on this, and Mr. Bannon and Mr. Grant looking at sweet area about and you introduced the concept of town centres. So the question is that enough? Sometimes pushback saying, well, as you say, oh, we're using this mixed use zone to cover everything. But I think the question is still there. A mixed use zone may be appropriate for the types of urban centres you have in small communities. So I'm interested to hear your response.
Yeah, I think
to whether whether you need a 3-tier hierarchy of commercial zones.
Well, even more, I guess, commercial centres or community centres as well. As Mr. Bannon was, I don't know what you would do with the mixed use zone if you were to introduce one of those, for example, in Kerikeri, then we would then be no mixed use zone. So, there's not a requirement for. And as I mentioned, like, yes, as Mr. Bannon identifies, there's a lot of a range of activities that's enabled, but that was the aspiration in the community, particularly to be able to use some of those areas of residential accommodation.
And that's why I made that point. That may be because a lot of your smaller communities are a range of activities that are there. You've got residential quite close, and you've got and that it may be that's the correct response for community with these size. Again, they keep giving us examples of bigger urban centres. And we're not being given examples of similar sized urban centres.
So how would I something like that? Yeah, look, as I say, it's not necessarily about what's there either, right? As I say, like, there might not be, as Mr. Bannon again rightly points out, there might not be areas of accommodation located in mixed use zone. Although there are some residential sites, particularly in Kerikeri, they're captured by. It's again about the aspiration and direction that was intended for the market. Look, I think it's pragmatically, we have acknowledged in this report that there are areas that not so much the mixed use zone, but there are areas that the zoning can be refined and additional management approaches can be taken, including large format retail. Certainly parts of public acknowledge that. Absolutely, we acknowledge that high here is a little bit out of step as well, and acknowledge that on the basis that can be sent to local land, requirement, whether that means more zones or more targeted provisions within those zones to deal with those requirements is a question. At the stage, I believe our intention was to introduce a large format retail zone and potentially to reconsider some of the, which not to the report, but certainly segments of the discussion as to really look at right here and how that's going to be managed. Yeah, we're not saying it's perfect, but I'm also haven't really seen any specific framework put to us that seems to resolve all the issues. There might be a zone somewhere where everything is permitted for everybody, I'm not sure, but while we have competing activities and responsibilities to manage those, obliged to do so.
Yeah, I mean, I think we're sort of minded to not introduce more complexity unless there's a demonstrable need to address an issue.
So particularly have 6 or 7 zones to play with moving forward.
And that goes for nesting tables as well. And I think acknowledge the issue. I'm just not convinced that introducing nesting tables throughout the plan is the way to address that one. I think there are potentially other ways to address it. But having said that, we may have been moving toward a nesting table anyway. This might be
The more drop-downs you have, the more layers you have, nesting table more complex, and the more opportunity there is for anticipated outcomes. I think what we've been trying to do is be very specific in our policies, objectives, and rules to deal with the things we want to deal with. Acknowledge that it's useful to what we have 100% agree with Mr. Baird there, particularly when it's only 1 or 2 layers deep. But I think there is a real risk that there's sort of just once you drop down, particularly the 3rd layer down, that you perhaps got to be again. You're going back to being specific again. But like I said, I think
it was funny looking at their example from the example and having grocery stores under the column trade retail.
Yeah, I contributed that way too, Mr. Chair.
Yeah,
I think
that's not how I understood how it read. It was a little bit confusing. That's how James pointed it out to me as well. But it was just
Let's make it simple by making it complex. And then there we go. We're already asking
yeah, I was going to do that, but
we get the overall potential that this plan is basically probably simple, but not complex, and that it's broadly enabled, potentially so, and that you're wanting to make the provisions simple. And we've sort of traced that concept of how we've received the evidence. I think so. We have sort of opted it's more complex complexity on the base that needs to resolve a specific issue and look at other options. If that's helpful back to you. Because there is a philosophy there we understand. The whole large format retail, I'll leave it to you to respond to us in the large format retail issue.
Yeah, discussing that with Mr. Baxter and Mr. Trinder. That was not something we made up. That was something that was based on quite considerable research and second generation plans. And I appreciate that it might seem a little bit unclear, but again, like it needs to be considered as part of the overall framework. And it's not just, I think it does reflect some of the issues with having this same design, but I think that provision becomes much more clear, I think.
So how would an OFR zone be introduced into the plan? Will you quickly go to be part of this process?
I don't think we have scope.
Where would you wedge it in?
Scope at least. I think we might look into what options we have and moving forward and do the best we can.
Sure. I mean, you can signal it, and so could we.
We have. Ms. Trinder has in her reports signalled an area, identified a spatial area, and Waipapa that, in terms of the
and I'm assuming it's a zone that applies to only Waipapa at this point.
I think so.
Just for one.
Just for one. And I mean, you can see by the question I have, Mr. Badham, is that large format retail is a thing, and it probably should be defined. Whether you use, I have no problem of you including it by area, because that is by definition something that is larger than something else. So, you know, a definition can specify that. I don't think there's any problem with that approach. And it's only because this thing is defined by itself. But I think there probably needs to, certainly if you're going to go towards a zone that you might bolt onto this plan once it comes off of it, if it deserves the definition, rather than just getting into the retail.
Is that a response, you know, what's in your report? What paper is that a response to a submitter, is it?
It's a response generally to a lot of submittals and what.
Yeah.
Because that's literally, I mean, it's light industrial zone, but it contains all the LFO, right?
Yeah,
We're going to have a good squiz around that today.
Yeah.
So.
I think what happened too, Mr. Chair, during the writing of this report, we also had particularly a lens as well, which it has sent more signals on. So we turned on to that when we were looking at the submissions as well. That's not to say that there might not be areas, for example, I'm thinking Kataia and like this down as well. But I think this is the one we had the most supporting information on, robust information to make that approach at this stage. So,
I've done a lot of talking.
And they wanted to, he wanted to, they didn't want to be confined to an area for LFR. They wanted to have the ability to put it wherever they wanted to. We Kerikeri Waikato don't want that. No, I don't think any town centre wants that. Because as you pointed out, conflicts with town centre and takes away from other retail functions. And then there's the pedestrian and vehicle movements that it would create, you know, in that town centre environment.
I think you can compare there's difference in granularity, right? What I would call the granularity of those uses.
Yes. Yeah.
In terms of built forming.
There's larger demand driven the large format retail. So I don't actually specify locations. I mean, what happened would be a case in point, but I have to specify locations and other.
So it's another example of a time where if you don't plan, you get planned, I would suggest. But I think with the support, in terms of development of the growth that we're doing, we're well supported by both economists and urban designers, and particularly the value that economists actually provide to growth planning. I think is actually positive, quite significantly positive and pragmatic. So about providing named and efficient and effective locations and where that might be. So I know those discussions were here. So there's certainly value in that contribution.
Briscoes and Rebel Sport, they're not large format, but they're trying to,
They're on the way.
they're on the way. And I think that shows that that's a good example of what, you know, how it's not, that it conflicts with the rest of the environment.
So it's an interesting example. Sorry, Mr. Chair, indulge me. So like they're essentially the same company. They're owned by the same company and generally co-locate.
Yes.
So would probably comfortably fit either in an LFR situation or in a town centre.
And the funny thing is that, you know, they do establish in smaller scales, but everyone's concept of Rebel Sport Briscoes is large format retail. I mean, and having something under 450 squares is the odd one now.
Yes.
That's the outlier.
Yes. It still comes with the same challenges. Those ones.
It's simple.
Yeah, and I suspect our friends yesterday from Vision Kerikeri, you know, would have a lot to say about format retail and places like Kerikeri Town Centre.
Yeah.
Yeah.
The positive thing I think about what they were suggesting is that they were talking about structures, they were talking about things like controlling branding colours on the face of it, which was helpful. I think that could get quite constrained as well. That's my understanding.
There are very few districts in New Zealand that control colour.
Only I would suggest centres of historic heritage, formerly
Queenstown,
Hastings.
yeah. Maybe
Probably also Hastings, maybe Hastings very light touch, yes. Very light space.
we're some second one's fine. Comes at my team.
You can see,
You can see a mitre tear from the International Space Station.
And I think one of the other points is the drive-through provisions as well. And that's obviously Mr. Bannon's going to provide some.
We don't deal with emissions, do we? That's here, so that's NRC.
Yeah, well, it depends on the question.
Well, drive-throughs, you know, from time to time over the last 10 years, I've had complaints from people who've been residents next to McDonald's because of the vehicle stench. When people are, yeah, the exhaust vents, yeah.
So there is obviously
Residential.
place. Yeah, and that's the sort of reason that it's to be considered an amenity issue. It's not just emissions issue, it's an amenity issue. So those are part of the reasons that we're looking to actually control, which is what covers. And it's just probably at the top of our mind, but it's actually quite a lot in this year this time. After saying I didn't have a lot of notes.
I was going to say, anything else to say about the impromptu evidence that we got on behalf of Top Energy?
It might be look, I think maybe something from a panel, some questions might be more appropriate because it would be, I think I'd rather also direct some information to the writers on that. If you've got specific questions that you feel that you might want feedback on, send it back to us and we can respond to it.
I just in terms of looking at the renewable energy provision for the renewable energy facilities, just struggling to read that up. So I have some decisions on that on the short cap, so I think I'll be going back and look at those.
And we just applied for renewable energy zone region.
Yeah, we dealt with that in renewable energy hearing about the industrial zone.
Right.
So yeah, I don't think it's appropriate to include that in industrial.
Maybe you could just cross-reference it for our benefit, that
Yeah.
it's already been addressed.
Yeah.
I wasn't part of that, I didn't do that hearing, so maybe for my own benefit, I need to go back and
Yeah.
I would suggest, look, if you look at our HBA, which is going to be submitted in evidence, like that assesses how much land we have available and need to provide, particularly now with the tier urban authority. I would suggest that we're looking at providing certificate. Yeah, it's about, say, for example, sort of watering infrastructure for the existing plants. So, so I'm thinking about transfer stations, substations, etc. That's fine. I think it would put us in potentially serious deficit in terms of our requirements for obligations in the UD if we were to be throwing everything in industrial. Again, noting that NAPA stage, the generation might be an exemption that we might consider when we get to the rezoning.
Yeah, that might be way against it, but it just seemed to me that he was quite specific on the Napa area. But he was seeking things on a wider basis. It wasn't really.
No, I think to be fair, that they've asked for quite a bit of land as part of the rezoning as well for Napa. My recollections, quite a bit of land.
Yeah, the other difficulty with some of those planning consultants and all like that is they're not bringing the clients along. So, you know, getting answers from Adam, for instance, bringing in wider things like, you know, the nesting table provision, not necessarily sure that it's a view that their clients promoted. Sometimes they're straying into areas that are wider than what their solutions actually solve. But
Yeah,
there's no control mechanism on that.
Yeah, Mr. Adams is trying to be helpful, I think. I appreciate that.
I think it is definitely, I mean, it's definitely useful to have this point of view.
Yeah, I think I might turn it over if we cover everything, if there's anything additional from you, any questions of your answers.
Pedestrian frontage.
Yes.
About that.
Along the Clyde Waterfront.
No, pedestrian frontages in general in urban zones and the impact it has on it. This is a good example. We're Woolworths, sorry, now. And, you know, it doesn't have that pedestrian frontage, yet it has a huge volume of pedestrians that, you know, traverse alongside that road. And it's more a transport issue, but I just want to, so just shut, but the volume of pedestrian traffic caused by that car park being on this frontage is a hazard. So, and nobody's, I don't know if we have that rule around pedestrian frontage for that as well.
Yeah.
Or not.
We've got a few problems with our GIS. I think there's quite a significant outage across New Zealand at the moment. So
Oh, sorry.
As far as I'm aware, the pedestrian frontage doesn't extend up that far, but I can't confirm that at this very moment.
Okay. Yeah. And the vet building as well, they're setback from the road, which has created car parking, and so we don't want any more of that on
I think
street frontages.
very important. And I think the level of, I mean, there's a million ways to look at design guidance and accounts. But for example, if you I look at JBC would probably be considered a rather lovely anchor.
Yes.
Entrance to town, very much a market code.
Yeah.
Unfortunately, over the other side, you have
Caltex.
a car park. You've got an empty car park in Countdown,
Yeah.
where actually built formally should be out
Yeah.
on the road, for
Totally.
example. So those are the sort of things, and additional consideration of pedestrian frontage is the sort of thing that we could look at moving forward. That's really good.
Yeah, well, I can say, for example, that the supermarkets have been forced to put their supermarkets out on the street frontage and their car parking is underneath behind. They do it kicking and screaming. The example I haven't gone to is the one on my yard at Ostend, where they actually created the tenancies and then you look into the supermarket. Takeaways sort of support the sort of things that people would do in addition to supermarket shopping.
Wow.
And then instead of having a sea of car parking out the back, they realised actually we need that land for stormwater detention, and so they ended up around car park.
Great.
And then once that happened, they went around and releasing all these press releases going, oh, look at our commitment to people as well.
But they were forced to.
It seems to me that once they embrace it, you know, they really celebrate it. It's just about, you know, like any business, it seems the cookie cutter can do it at least cost, and they'll do it. So you've got plenty of opportunity. Supermarkets are an interesting animal because they sort of need to be in the centre of towns, but they sort of run counter to the pedestrian frontage outcomes.
Absolutely.
Unless you make them.
Yeah. Okay. That's wonderful.
I haven't got any further questions. I've been asking them as we go. So what sort of right from the start. So
No, that's pretty fine. And most of those witnesses we've just asked the questions as we've gone, which is quite useful.
yeah, so I think because this has been a hearing that hasn't been attended by those people who indicated we've been able to use that time quite productively. So thanks for your interaction on these things. Shall we wrap it up? Anybody else? Oh, sorry, any more comments to come from any other council officers? Any else?
Thank you.
So I'm just going to let you know that we'll break for lunch now, or we can just go. And we're going to do some initial deliberations because we're here. And then we're going to go and have a look at some sites. We're going to go to Kerikeri, we're going to go to and have also see if we can't have a look at some of the land that'll be subject to the 15D. Because Alan and I will be on that land.
Who's on that? Just you two.
Alan and I.
Yeah.
Alan and I, listen.
Oh.
Because she does it.
And Peter.
And Peter, who's our urban design
I want
coach.
to make one request. Can you please go to Harmony Lane and have a look around Harmony Lane?
Harmony Lane, so tell me where,
Thank
in what
you.
context?
Should we close it? Kerikeri? Yeah.
Oh,
Yeah, we're gonna do deliberations.
Yeah.
Okay, I'll do it now. Kia tau, kia tātou katoa, te atapai o tō tātou ara ki o ihi karati me te aroha o te atua me te kiwinga tahitanga ki te wairua kapu ākia ki āmuri. Thank you. Stopping, no recording.
Harmony Lane, Waipapa.